Good evening, everyone, and welcome to tonight's Dominate Law live panel discussion. The Future Proof Law Firm, What Lawyers Must Do to Stay Profitable. I'm Angie, and I'll be your moderator for today's conversation. Tonight, we'll be talking about something almost every law firm is dealing with right now. How to stay profitable while client expectations, pricing pressure, operational demands, and team capacity challenges continue to evolve. Because the reality is, being busy no longer automatically means being profitable. A lot of firms are working harder than ever, but still struggling with margin pressure, inefficient systems, unclear delegation, pricing uncertainty, and operational bottlenecks that quietly affect long-term growth. So, tonight, our panelists are going to help unpack what's changing, where firms are losing profitability, and what practical steps leaders can take to build firms that are more scalable, sustainable, and future ready. Now, before we begin, just a few quick housekeeping notes for you. First, today's session is being recorded, and everyone who registered will receive access to the replay afterward. But don't let the recording make you passive. The real value comes from listening closely to the discussion and perspective our panelists share alive. Second, feel free to use the chat throughout the session for reactions, comments, and discussions. And if we do have time near the end, we'll be opening things up for audience Q&A as well. We've got Ashani, who's supporting us behind the scenes today and will be helping with chat, links, and logistics throughout the session. So before we continue, I do want to quickly mention that Shireen Hilal was originally scheduled to join us tonight, but unfortunately, due to a family emergency, she's no longer able to be with us this evening. So we absolutely understand, and we're sending her and her family our best wishes. That said, we still have an outstanding panel lined up tonight, and I'm really, really looking forward to the conversation ahead with Ken, Mitch, and Paul. I also want to take a moment to thank the sponsor of today's panel, Ekwa Marketing. Now, Ekwa Marketing works with law firms and professional practices to help improve visibility, attract better fit clients, strengthen authority online, and build more effective growth systems. Their work focuses heavily on SEO, conversion-focused websites, educational content, and long-term client acquisition strategies. They work with firms across the United States, Canada, the UK, Australia, Ireland, and New Zealand for more than 15 years. So we'll hear a little bit more about Ekwa later in the session, but for now, thank you to Ekwa Marketing for supporting today's event. Now, before we introduce the panelists, I want to quickly frame tonight's conversation because one of the biggest challenges law firms are dealing with right now is the idea that being busy automatically means being profitable. And we know that's not always true anymore. A lot of firms are working harder than ever, but still feeling pressure around pricing, operations, delegations, team capacity, and overall profitability. And the firm that are going to thrive over the next several years are probably not just the firms with the most clients or the busiest attorneys. They're going to be the firms that build better systems, operate more efficiently, delegate well, manage capacities carefully, and create more clarity around how the business actually runs. Because growth without structure can very quickly turn into more stress, more bottlenecks, and less profitability. And that's exactly what tonight's conversation is really about. And honestly, if these are the kind of conversations you enjoy, they continue every week on the Dominate Law podcast as well. The podcast covers topics around law firm growth, profitability, leadership, innovation, operations, marketing, and the future of legal services. So definitely make sure to subscribe and check it out after today's session. And with that, let's officially introduce our panelists tonight. Our first featured panelist is Ken Crutchfield. Ken is the founder and CEO of Spring Forward Consulting and brings more than 40 years of experience across software, legal innovation, information services, business transformation, and strategic growth. His background includes leadership roles at Bloomberg BNA, Thomson Reuters, LexisNexis, Dun and Bradstreet, and CCH Walters Kluwer. Ken brings a really valuable perspective around innovation, profitability, systems, and strategic transformation inside legal organizations. Ken, thank you so much for being with us tonight.
Thank you so much for having me.
Our next panelist is Mitch Kowalski. Mitch is an experienced in-house real estate and commercial counsel with more than 20 years of experience advising on major transactions and complex commercial matters. He's also widely recognized for his work around legal innovation and the future of legal services, including as author of The Great Legal Reformation and Avoiding Extinction. Mitch brings a really important system thinking and client value perspective to this discussion. Mitch, welcome.
Thanks for having me.
And finally, we're joined by Paul Saunders. Paul is a partner and chief strategy and innovation officer at Stewart McKelvey. Over the past decade, Paul has led major innovation and strategy initiatives across pricing, profitability analysis, process improvement, AI, legal project management, data analytics, and operational transformation. He also leads the Fortified Firm initiative, helping firms prepare for the realities of the AI era. Paul, thank you for being here tonight.
Thanks, Angie. Great to be here.
Now, before we jump into the panel discussion, I want to quickly highlight a few of the major themes we'll be exploring tonight. We're going to talk about pricing pressure, changing client expectations, profitability, delegation, operational efficiency, and what it really takes to build a law firm that can grow sustainably without losing control of quality or capacity. So overall, this is going to be a very practical conversation around building healthier, more profitable, and more future-ready firms. With that, I'm going to stop sharing the slides so we can move into the discussion. And just as a reminder to everyone attending live, feel free to drop your thoughts, reactions, and questions into the chat throughout the session. All right, so let's jump into the conversation. Ken, I'd like to start with you. Which market signal most clearly shows that hourly billing is losing credibility with clients under pricing pressure?
But it's funny you say that because I actually would be a little contrarian about this and say that I think the billable hour is going to be around for quite a while. And it's how value is basically measured, and it's a good proxy for value. And unfortunately, even clients, especially I work more with big law, they are looking for an understanding. So they want to know how many hours it took and have a fixed fee or an alternate fee arrangement oftentimes. I'm even hearing just in this past week that there are some firms that are being asked to abandon an alternate fee arrangement to go back to billable for a while, just to be able to see how the metrics are changing with AI, to see if AI is actually reducing the amount of time on key tasks and matters. So from that standpoint, if I go back to your question, I do think the signal itself is higher rates. I think you're going to see with outside counsel guidelines for larger corporations in particular, driving that feedback loop and expectations of what you can bill and you can't bill, it just forces rates up. And I do think there's a lot of movement with AI native law firms, legal service providers, taking work in-house if you're a corporation, that is changing those dynamics, and that will put the pressure on if rates go too high. So I think that's the place. I do think that the market share of billable hours will shift, but I don't think it's going away.
Can I jump in? Just sorry, Ken, we had a bit of a conversation about this before. I think what's interesting about Ken's points is if the rates go up, at some point clients will face traumatic sticker shock. When you start to see a second-year associate billing at $1,400 an hour, that I think that will dramatically shift us back to, guys, this is a number I cannot live with. This is not a number I can sell to my CFO or the board. I think, Ken, if you're right, rates will go up, and then all of a sudden will hit a tipping point where clients will just say, I can't justify paying that much for a first or second or third year lawyer.
I think you're right, especially for the first or second or third year. And there are corporations that won't pay for a first year attorney right now, anyhow. And I do think that it will create a much more honest conversation about how does a law firm actually invest to build out the technologies that automate to reduce the hours. So I think it's going to be a very interesting and frank conversation between clients and firm. Now, smaller firms, they've got a little different situation. Especially if you're, two, three, four, people in your firm or a handful of partners, or if your work skews a little bit more consumer, but I'm sure I'll hit on that a little bit more as we go through this.
Yeah, that's definitely really interesting. It also connects with maybe the operational pressure that is going on inside firms as well. So, Mitch, I'd love your perspective here. From the client perspective, what behavior are you seeing that's forcing firms to prove value earlier in the relationship before the invoice even arrives?
Well, I think in general, we've seen a trend where in-house. So let's look at large legal consumers, so corporations. Growth of in-house counsels has not abated. It continues to build in a lot of companies. Certainly, there are a lot of companies who've just said, we want to spend more money on our inside attorneys than on outside attorneys. So it really forces firms to show, especially if you're trying to break into that market, to say, hey, here's my value proposition, right? Here's what I'm going to do for you. And I'm not going to charge you for this, and I'm not going to charge you for that. I'm going to offer you things that your in-house department can't have. Maybe I give you access to my precedent system that will help you, because in-house lawyers have notoriously bad precedent systems. It will allow you to use various other things that we've developed in our firm on a free basis, in return for your business. But the concept of a free-for-all clearly is over and has been over for some time, but I think it's just going to start to accelerate. So prove your value immediately, be very highly commercial with your advice. That's something most clients really value. They don't want things over lawyered. They just want to get to the solution. Help me get there, help me manage the risk, and then we'll have a good relationship.
Could I just jump in there quickly, Angie? I had a thought on that too.
Mhm.
I think what law firm lawyers can do to differentiate themselves is they're just getting more reps in because they're working for many more clients, and so they have a added level of expertise that in-house counsel just won't be exposed to. So I think you really have to showcase that expertise early on and explain why it makes sense to send some work outside the organization into the external counsel. But you got to show that early on to prove that value, because the risk is, particularly with AI, that more and more of that work will come in-house over time.
Yeah, 100%. Like, because if the AI can give, if the AI really is the source of the knowledge of the law firm, then the in-house counsel are always going to say, and myself included, are going to say, well, I can just prompt my system to give me a pretty good answer on this for the cost of my tokens, or the cost per desk, or whatever I'm going to do. And I will manage that risk myself. So 100%, Paul, I agree with you.
All right, that's really interesting. Now, Paul, let me bring you in here. How should firms think about balancing pricing certainty versus flexibility when the scope of work still isn't fully clear?
Yeah, it's a huge challenge when when trying to have certainty while scope is unclear, right?
Yeah.
And I think the focus shouldn't be on absolute price certainty in terms of the dollar amount, but certainty in the mechanism to determine what the price will ultimately be based upon any of those scope changes, right? So for example, you could have a fee structure like a contingency fee. That's a percentage of a settlement amount. It could be a percentage of the purchase price of a transaction. And if those numbers aren't clear, the price is unclear, but at least the mechanism is clear. So the client knows, ultimately, if this settles at this amount, I know how much I'm going to have to pay the law firm. Other pricing structures that I really like that kind of work with that would be like a fee collar kind of structure. So you could have a, rather than a fixed fee or hourly billing, kind of have a hybrid where we expect it's going to cost $10,000. And if it comes in below the 10,000, we split the difference with the client. Or if it goes over, you split that excess. So you've got aligned incentives in place so that if you do have an unclear scope and the scope of work ends up being far lower, well, the law firm benefits because they can bill at a premium. The client benefits because they're paying less than if it was a fixed fee price. And if that scope becomes far beyond what was anticipated, the law firm still covers its cost past that threshold, but at a lower percentage. And the client doesn't have to pay quite as much if they run an hourly billing structure. So what it does is it both the law firm and the client have incentives in place to be as efficient as possible. Where if you use these other tools like the fixed fee or the billable hour model, the incentives are misaligned and you're not necessarily paddling in the same direction. So that is one of the strategies that we would use when you've got an unclear scope of work. Um, I think you can also, it's important to clearly document what is included in the work, what is excluded, have mechanisms in place to change the pricing if the scope changes. And that's just, solid project management rigor, that's clear scopes of work, that's proactive communication when those scope changes happen. So you can have that informed conversation with the client. Listen, we thought this was going to close on this date. It's going to close next month and it's way complicated now. So let's talk about what the implication on the price would be. So I think it's about proactive communication, and I would err on the side of flexibility, but with a pricing structure that's still clear.
Yeah. Let me just jump in there. Sorry. But there's from a client perspective, and this harks back to the question you just asked me, Angie, is that if I see a firm demonstrating that kind of creative way to manage a file, that impresses me a lot more than I'm the smartest person in the room and therefore just hire me because I'm a really great lawyer, right? If I could see that they've really thought this through and understand that they're going to take some of that risk, and yes, if they do really well, I'm more than happy to give a bonus. I think there are a lot of companies out there, in-house legal departments, who are willing to pay more for certain results if it's shared on the other side, so that if things go crazy, everybody shares the pain. And that's a signal to the market that your law firm really understands the client perspective and is willing to share in the good and the bad.
Hmm. And I think it's so important, Mitch, that we develop the expertise within our lawyers to not just be good lawyers, but to be good business people too, and to understand pricing and understand profitability and understand the costs and understand different pricing mechanisms and project management rigor. And I think as we enter into this era of constant change with AI, it becomes even more important that we double down on those business skills and not just focus on the practice of law, but on the business tools. And clients like that because they're business people too. They understand their cost. They understand the idea that you have to have a solid margin to do the work. And so showing that sophistication, I think you're right. It's a real way to differentiate yourself as a service provider.
Yeah, from our perspective, we want our lawyers to be successful, otherwise your firm won't be around and that's not good for anybody. But if demonstrating the the give and take, and training lawyers to understand that and not just say, well, I spent a lot of time on this file, therefore you should just pay me whatever, X times the hourly rate, you're spot on. That's brilliant.
Ken, let me come back to you. What separates genuinely useful innovation from expensive distraction when firms are trying to improve profitability?
I think, did we lose Ken?
I believe Ken is having a power cut, so maybe Mitch or Paul could answer that question. Would you want me to repeat the
Yeah,
question?
repeat the question.
If you could, yeah, I was kind of zoned out because it was Ken's question.
Okay, so what separates genuinely useful innovation from expensive distraction when firms are trying to improve profitability?
I'm happy to take this one, Mitch.
Start that off
Um,
and then I'll chime in. Sure.
yeah, I think it comes back to a goal, a strong goal. What are you trying to accomplish? Don't jump to what's shiny and new. Jump to something that's going to solve a real problem. So I think you start with articulating what is our goal? What do we want to accomplish? What does success look like? What are the simplest things that we can do with the biggest amount of benefit to achieve that goal? And that might end up being some innovative solution, might be some AI platform or tool. But it might also be just getting a bunch of people into a room with a whiteboard and sticky notes and mapping out a process and figuring out what's the simplest thing we could do. So I think there's a tendency now with AI to jump to those solutions and to kind of embrace this technology because it's interesting and it's shiny. But oftentimes that leads to wasted time and effort. And it's better to focus on what makes sense, build a foundation of success, and then iterate from that particular point on.
Yeah, I mean, really understand what your pain points are in your practice and really what part of your practice makes you the most money. Let's just be blunt about this. Okay, so is it real estate? Is it family law? Is it corporate? And say, okay, that's 50% of my work or 45%. And okay, and really look at, as Paul said, is what are the problems that we're having with this? Are we too slow? Are we making errors? Is it, all these sorts of things, and then focus on how to solve that without technology. Look through like a process-driven approach, as Paul said, and then start and think, if we've done all that we can with what we have now, okay, now we look to see what else is out there that'll help us in this area. And that might also carry over to our second largest area of practice. So we can, build some synergies. But yeah, shiny object syndrome is a bad thing.
Mhm. All right. So before we continue with the second half of the discussion, I think that's actually a perfect place to pause for a moment because what we've been talking about tonight is exactly why the next step matters. So we've talked about pricing pressure, operational bottlenecks, profitability leakage, delegation, challenges, capacity strain, and the need for stronger systems. And for many firms, the challenge isn't that they don't care about profitability. The challenge is that they don't always have a clear picture of where profitability is actually being won or lost inside the firm. So, because of that, today's attendees have been given a complimentary opportunity from Ekwa Marketing. This is a gift from Naren Aruraja, who is the founder of the Law Expert Panel Webinar Series and CEO of Ekwa Marketing. Ekwa is offering attendees a complimentary 45-minute strategy session and audit focused specifically on growth, visibility, profitability opportunities, operational efficiency, delegation structure, and long-term scalability. You'll walk away with practical insights into areas like pricing and positioning, client communication, workflow efficiency, delegation opportunities, and a tailored 90-day growth roadmap for your firm. This is especially valuable for managing partners, law firm leaders, COOs, operations leaders, innovation leaders, and firms currently navigating growth or pricing pressure. So to claim it, you can scan the QR code that is on the screen or use the link that Ashani will be placing into this chat. There's absolutely no obligation. It's simply a focused strategy conversation to help firms better understand where they are today and where opportunities may exist moving forward. Once again, it's a complimentary complimentary opportunity that Ekwa Marketing is offering you. So I definitely encourage you to take advantage of this complimentary audit. And with that, we'll continue the discussion. All right, so Mitch, let's jump back into the conversation. At the very first budget conversation, what boundary needs to be made clear before client expectations start drifting?
Yeah, I think staffing and understanding that we don't have an unlimited budget. I think that law firms often assume that when they're hired for work, that budget is unlimited and we're willing to pay anything there is. And so therefore they will staff it to the max for the purposes of just generating as much revenue as possible. So, it is for me a real sort of hard conversation that you just have to have and say, look, I don't want three people on this call. Why are there three people going to be on calls? Who's actually going to do the work on this? Here's what I'm not going to pay for, and so on and so forth, so that we really set out the rules. It's really much better for the relationship to set out the rules right from the get-go as to what our expectations are from a billing perspective, so that the law firm's not surprised, and more importantly, we're not surprised when we get a bill.
Could I just ask Mitch a question on that, Angie? Would you mind? Mitch, I'm curious, like in those early discussions with clients and, scope is uncertain, price is uncertain, would in-house counsel want the law firm to say, what budget are we working with here? What can we do to conform within that budget? Like, is that a good way in some cases to start the conversation? Because I think oftentimes it's, here's the work, you tell us how much it's going to cost. But, the way I often describe it is if a person wants to buy a car, they say, I want to buy a Volkswagen Jetta, but oh well, the law firm sells them a Porsche. They're not going to be very happy. You got to deliver what the client is prepared to purchase, and that means you might not be getting everything. But that's a dialogue and a conversation. So is that a useful step early on to ask that question? What's the number that we're looking at here, and we'll conform to that.
100%.
Yeah.
And nobody starts that way.
Right.
Everybody starts with, sure, we can do it. We're super good. We'll do this. We'll hire, we have this person who's really good. We'll put her on the file. We'll put her on the file and blah, blah, blah. And then it's like, hold on. So yeah, please ask for the budget up front. And then let's talk about how we can manage this. Assuming, and it's a different conversation. Well, it should be the same conversation if it's a consumer law practice as well. It's like, I'm buying a 7-Eleven. How much, what's your budget? What were you thinking of for legal fees? And if they say, $1,000, you'll say, well, not even happening. But and then you manage that before you even start going down the road. Because it's way worse to deal with it after the fact. And I'm unhappy, you're unhappy, then I give you bad reviews and et cetera, et cetera. So 100%, please have that right on day one.
I think it's that lawyers just hate talking about money. They think it's icky. They want to talk about the law. They get excited about this new case. Like, oh, we don't want to talk about that. That's just eh. But then what ends up happening is you send out a bill and then it gets way ickier at the end of the day. You tick off the client, they don't go back to you. There's an awkward conversation. You got to write off all your fees or a good chunk of it, and that doesn't benefit anybody. But how do we get lawyers past this idea of not being able to have those frank conversations at the outset? Clear scope of work, clear pricing mechanisms, and have that as a conversation as business people, right?
Well, it would be helpful to stand in my shoes.
Yeah.
Getting the bill because the lawyers are pushing the bills out and never, not always, but a lot of times they're not thinking, man, would I pay this bill? How would I react if I just got this bill for this amount of work, right? What would my reaction be? And so if the more you can stand in the client's shoes and go, yeah, I wouldn't pay 10 grand for this. It would be helpful, but
Yeah, I think it's so important to kind of put yourself in the other side and try to align those incentives and empathize with with other perspective.
I'm
We
back.
have Ken is with us.
Yes,
Uh,
I ran a couple of blocks. Power was out. Ran through the rain. Had to change shirt. My wife won't let me go on
oh,
without a hat now. So,
It
but
looks
I'm
great, Ken.
back, and the lights are flickering a bit here. So hopefully, ask me a question quick. So,
yeah, all right. So the question was, what separates genuinely useful innovation from expensive distraction when firms are trying to improve profitability?
sure. So I'd say first off, stay away from the light. The bright, shiny objects are a distraction. Make sure that you know what problems you have and have some general awareness of what technology can do. But start with what your problems are, what are your goals, and then work from there and apply technology that works for what you're trying to solve. I think that's the core and the center of it. There's absolutely a need to understand these broader game-changing technologies that are going on. That's something that you'll want to know. You're going to need to keep a little current on what Gen AI is doing and how that is empowering change because it just is. But I think the core is just starting to think about things, take some action. Don't worry about if you get it right because in 18 months it's all going to be different anyhow. So oftentimes this is going to be the learning and there's going to be opportunities to catch up or even leapfrog as you learn, but it's take one step, put it in front of the other and take another step and take another step and learn.
That's perfect. We've got a few questions coming in on our chat. We'll definitely get to you during the Q&A. So for now, let's get back to Paul. So where does delegation usually break down when junior lawyers receive work without clear review expectations?
Yeah, I think it breaks down at the very beginning. I think you have to start delegation uh, right if you're going to get the right outcome, right? So I think, and this becomes even more important in this era we're entering into now with AI uncertainty, right? I mean, the dynamics of the market are changing, how we price our services, how legal services are valued. It's so important. But you know, when we're training our lawyers on this, you need to be really clear. What is the expectation in terms of the work product? How much time is it going to take to get that work done? Make it really clear. Come back if there's any questions or clarifications that are required. Um, and I think this is so important too. I think uh, there's this issue that we struggle with is like what I call the AI training conundrum. This idea that the more our junior lawyers become reliant upon AI, that's going to deprive them of valuable learning opportunities. Like I learned to be, a corporate lawyer through reviewing hundreds of leases and due diligence and reviewing material contracts to draft my own contracts. Litigators learn how to persuade a judge or a jury by reading cases and writing research memos and doing a lot of that grunt work that you build yourself into those higher levels. And with AI, we're depriving people of some of those necessary learning opportunities. That doesn't mean to say don't use AI. I think you have to, but we need to mitigate those risks. And I think we need to, when we delegate, we need to double down on mentorship. And we need to say, it's not just do this task and report back 3 weeks and it better be perfect. And then I will mark it all up and give you a terrible review. It should be an ongoing discussion and dialogue where when I'm doing the work, let's work together. Let's collaborate in real time. Let's try to fill those gaps in knowledge that are going to arise as a result of over reliance upon AI. So I think delegation, to answer your question, has to start from the very beginning, but it has to continue throughout that engagement, showing their juniors exactly what they need to do to develop those necessary skills that I'm afraid they're going to be deprived of in this era we're in now.
Hey, Paul, just a couple of thoughts on that too. One is I find it ironic because in order to get a good prompt, you have to provide good direction. So I feel like some of what AI
Yeah.
actually provides is the opportunity to learn how to communicate effectively, which oftentimes, whether it's medical community or law, it's kind of just go figure it out. Let chaos fill the vacuum, and the smart attorneys will figure it out and come back with the right answer. And there's still an element of that we have to get. Have to embrace to make sure that there's resourcefulness. But at the end of the day, I think that aspect of learning how to be a better communicator is going to be important. The other point that I was going to make, what was the other point? Oh, is calculators. We've been through this before with calculators. So I do think there are ways to find harmony and balance between using the new technology and not having to just go do everything raw by hand over and over and over again, brute force. There's a value in that in the experiential, but there's a balance.
I love that first point. You made kind of the second one too, but this idea that can AI teach us to be better at delegating? Because I think what happens is you're delegating to a junior lawyer and you forget that they don't know anything. You forget that they just got out of law school. They've never done this before. And all these words, all these terms. I remember being a junior lawyer, sitting in a meeting and being told what to do by a senior partner and not understanding half of the words that were just thrown at me. And I was too embarrassed to say I didn't know. But we assume AI knows nothing because it's a computer. And so we have to give that context. We have to say, you are this and I am this, and this is this document, and I want this output, and I want you to do this, and I want it to be done this way. And it's a way, it's like the silver lining of over-reliance on AI is that it might actually make us in part become better delegators. So I like that spin on it.
Mitch, would you have any thoughts on the question?
No, I'm with I think there is, and you'll see over time, because we're still very early days in terms of seeing AI as a tool for learning and developing lawyers. Nobody, we haven't quite figured that out yet. But I mean, this is a good example of what Paul and Ken were just talking about. Just teaching you how to prompt better makes you a better communicator. So what else can we use AI? Can we use AI to train our lawyers to be better drafters? Can we create an agent that gives crappy drafting advice, and we ask the juniors to say, okay, does this really make sense to you? Are you sure? The AI spit it out, but what about this? What about that? And get them to train in that way. And quite frankly, as I think Paul mentioned as well, it's like training in law firms is pretty crap as it is. Like, let's be real brutally honest. My training was horrible. It was, as Paul said, here you go, good luck. And somehow magically by osmosis, some people pick it up, some people don't. But I think the opportunity of AI is it will give the potential to really be thoughtful about how to train our lawyers, because now we have to be thoughtful and diligent about it. We just can't say, follow me around and magically you'll pick stuff up. Those days are gone. So I'm hopeful that that's the way it'll go.
Really, really interesting. I mean, great insights over here. Ken, I'd love your thoughts. During intake, what decision point usually reveals whether a firm can realistically handle new work profitability or profitably?
So I've got a couple of thoughts on this one. One is it depends on the size of the firm. So a big law firm is going to be looking at things maybe differently because those steps of intake are spread out. It's about targeting and marketing and business development and a whole process qualifying as you're walking through that, and that could take a couple of days. It could be a conversation after a dinner or something, or it could take tenure. It can be that broad. So I think tying it back to what you do as a smaller firm or a mid-tier firm is really focus on what is your profitability, know what your profitability is, what are the things that are good engagements for you, focus on a strategy of how you're going to reach the clients that fit that profile and can value what you can provide, and you can do it profitably. So I think of that and say, for a personal injury firm, intake may come in at the same time that your marketing and business development all play out, because you got a phone call and you got to work through it. And I know a friend of mine from high school, personal injury lawyer, and he is more inclined to take cases where there is actual medical diagnosis, a broken bone, something like that that's tangible, as opposed to soft tissue damage and a chiropractor said this. And now there's an ethical aspect to this too, that each state and jurisdiction and province in Canada all have laws and ethics. So you've got to go through both the ethics of the practice, but also your own personal ethics and morality and how you do this. An extreme case would be bankruptcy, where maybe you target your marketing to certain zip codes that are more affluent or would be better and more profitable. There's an ethical aspect to doing something like that. But I'd ultimately kind of take it back and say, Fisher Phillips Law Firm is a large labor and employment firm in the U.S., and they've done a great job at collecting, organizing their data, which, by the way, is one of the first things I would do before I go off and build a technology. Get your data together, and they marry that with the public docket of information in the United States, and in doing so, they can identify the metrics that mean when a client comes in, you've got a good case, but I'd settle. Versus, oh, you've got a case and I would take that to court and I would go all the way to court if you don't get a good settlement. And they know the metrics very well. And I think that's the standard that we can aspire to as law firms across the board.
But what about, sorry to jump in, guys, but so Ken and Paul, this is a good question for you too, but lawyers are afraid. They all think that the file they have now is the last file they'll ever get. So everything that walks in the door, they better take that work because they never know when they'll ever get work again. And so does not fear drive a lot of poor decisions on taking on files that maybe you can't manage or stuff just because you're afraid? You need the money. You got to make rent this month. You got to make payroll this month.
I'm sure that can play in, but I think this gets back into the S word, sales, which is something that I think lawyers tend to kind of shy away from. But understanding how sales works in a more traditional business where you are actually working on multiple time horizons at the same time. So you may have some work now, but you've got to devote a certain amount of time, effort, and thought to how do you get that next set of clients in. So whether that's sending holiday cards or reaching out and making phone calls during some of those slower times, if you have slower times, are all things you need to be doing to work the time horizon so that work comes in, especially work that is a better fit and match for you. Paul, do you have anything to add?
Yeah, no, I mean, Mitch, you make a good point. I do think that it's true that, lawyers want to be busy. And when there's an opportunity to do work, even if that might be at a lower rate or a lower price, there's this desire to take that on. And I think we need to resist that urge because I think not all revenue is treated equal, should be treated equal. You have to factor in the associated costs that go along with it, right? You have to think about what's the price we're going to charge here. What are the costs associated with every hour? And I think you mentioned, Ken, about profitability. And I think law firms need to develop profitability models. They need to understand the costs for even if you're not working, you're really working on a fixed fee or a contingency fee, you still need to know your costs. You still need to predict how much time it's going to take, what the hourly rates are for your timekeepers, how much revenue you're going to generate, what the cost is associated with each one of those hours, what's the margin, and look thoughtfully at the potential engagements that are coming in to maximize the net profit for the law firm. And not all revenue is good. You could have two engagements with the same price tag, but one of them is way more costly because it's serviced by higher cost timekeepers. Like if a senior partner is doing work for $10,000 versus a junior associate for $10,000, the firm isn't making nearly as much money on that $10,000 that the partner is doing because they're taking the vast majority of that price home in the form of their income. So the firm collectively is not benefiting. So I think we need to factor that in. And I think, Mitch, you're absolutely right. It's a concern. And a lot of lawyers want to take that work and be busy, but we have to resist the urge to jump to all the work because that can diminish our value. It could kind of diminish our expertise. It could change how we're perceived in the market if we're a race to the bottom on the lowest hourly rates. And it also deprives us of those great opportunities that do come along that are higher profit. So I think it's a really important dilemma. And it also goes back to that issue that we talked about before about not only training our lawyers to be good lawyers, but to be good business people and understand the economics of the practice and understand cost and understand pricing and be thoughtful in project management rigor so that you don't have those situations that compromise your margins just for the sake of being busy.
I'm really loving these great insights we're getting today. Mitch, let me come back to you. And I think this is a very interesting question as well. I think a lot of our attendees will be very interested in hearing, I believe, all of your insights on this. So please feel free to jump in. Mitch, let me ask you this question. How should firms decide which transparency practices actually build trust with clients under fee pressure?
I think be 100% transparent, just 100%. Like I don't see any reason to not be fully open and honest with what you're dealing with at the firm, whether it's staffing pressures, whether you know your level of business or whatever. I think I look at it as a relationship. I'm looking for a partner in my work. I'm not looking to be a cop. I'm looking to build a relationship, and building a relationship means we're open and honest with each other on exactly what we can do, what we can't do, and why. And if you really lay it out and are being honest and open about it, I think that resonates with me, and I think it resonates with a lot of clients. And so I would just say, just don't be afraid to be honest about the situation.
You know, one thing I was
Mitch,
going to mention
go
here
ahead,
was,
Ken. Yeah,
sorry,
no.
one thing that I was going to mention here is the whole discussion of value and making sure that you're clear in terms of the things that you're doing that you're not billing for example, as another means of transparency. That could be initiatives that are going on that could benefit work that's been done where you've already written it down and said, no, I'm not charging for this. I think those things are really important. Just a personal experience that's not law, but when I took over a business about 15 years ago, they had been giving away like $25,000 worth of work with every software purchase that they sold. And then they couldn't get to that work. And we ended up switching it around, and it said, this is $25,000 worth of work. Let them mark it down to zero. But we doubled the price of the average deal by changing that metric around, because the amount of discount was so significant relative to what the value was. And once we did that, we got a higher average deal size, which allowed us to then hire a few people to actually do the work that we were having a hard time servicing, that we were, quote, giving away.
I had a question just for Mitch on the transparency answer, because I kind of a slight counterpoint. I wanted to see what you think about it, Mitch, because there's this concept of shadow billing, right? So say if you're working under a fixed fee pricing structure, right? As opposed to a billable hour approach, where you would share all your time entries, you would share your narratives, you would know exactly the hourly rates, you'd multiply those by the hours, you get the full amount. When you're dealing with a fixed fee, shadow billing, or showing the narratives and the time entries when you're under that fixed fee, discloses things like, how close did you get to that fixed fee amount? Did you go over? Did you go under? Is the firm getting a big premium on this work because they were efficient? So in some ways, that transparency can actually deprive the firm of the incentives and the rewards to be efficient. And if you're showing and disclosing the narratives and the time entries all under a fixed fee, it might drive the opposite behaviors that might be against the client's interest, which is being inefficient. So I'm curious if there is a limit to transparency, or if it is, do you think in all cases just share all that information, the time entries, the narratives, and even if there is a big premium, trust the client to just say it's okay that the law firm gets a premium on that one?
Well, I guess there's two ways. There's a way to look at it is, when I think about value billing, I'm not doing the math on the hours, because it is the value to me as a client is, yeah, I'm willing to pay you 10 grand to do this piece of work. For me, and maybe I'm an outlier in the client world, but it's like 10 grand, that's great. You do it in 4 hours, good for you. Don't care. I agreed to, we all agreed to this. We're adults. We're contracting parties. We're equal parties. We agreed to 10,000. I give you 10,000. That's sort of where my mind starts, but it stops. So shadow billing to me just is a pointless exercise. But I know that if you view value billing as a mathematical equation, then you start having that problem. And I think if I'm a lawyer in private practice pushing value billings, I'm not doing the math on that. I'm just saying, and when I had my own practice, I would just set fees. It's like, okay, your lease is 3,000 square feet. The price is this. It's 10,000 square feet. It's this, because I know it's going to be a little bit more complicated. And I never had clients, my leasing clients, ever come back to me and say, okay, but how many hours did you really spend on that? So I think if you have the conversation at the beginning and we're all on the same page, then I don't think you go down that road of having a mathematical equation to it.
Yeah.
I mean, there's another story that I like to tell. It's a little bit off topic, but sort of similar. Is many years ago there was a client who was doing some kind of corporate transaction, and late on Thursday night, the transaction was supposed to close on the Monday. They found some kind of problem, and they talked to the law firm, and the law firm put 4 associates and 2 partners on it. Friday, Saturday, Sunday, solved the problem, closed on Monday. And they gave the bill to the client, and the client said, the amount of time that you guys billed, the value of that to me was way more than your billing, right? He said, you should have just told me it was $500,000. I would have agreed to it. Instead, you sent me a bill for $250 because you did your hourly rate. So that's, to me, is, let's have the value discussion and not go down the road of doing the math.
Yeah, agree.
Yeah. One quick point here is, I think there are some firms that do work for like insurance claims or healthcare, and oftentimes those are substantial, and they're very commodity oriented. So it's a different animal. And so I just want to observe that there are different dimensions where it is a true relationship. I think the more transparency makes a lot of sense. But if it's commodity work, that's going to be, if you can't do it for this price and going somewhere else, that may change that dynamic a little bit.
Yeah, good point.
All right, so we have a few minutes left. Let's open things up for audience Q&A. Again, if you'd like to ask something live, feel free to raise your hand, or you can type a question directly into the chat. So we have one of the attendees who had asked for a question. Robert Fuchs said, on this topic of costing, what are you guys basing the quote on? Where does the budget come from? I think our value and therefore our cost should be commensurate with the amount of risk mitigation and transaction consulting, but I rarely see fee codes tied more to value of risk mitigation and transaction value.
I've got some thoughts I'm happy to share. Kick things off, Angie. That works?
Yeah, please.
I think Robert asks a great question, because I think you have to tackle it multiple different ways. Like, I think you need to start with understanding what your costs are. Even if you're not billing by the hour, you still need to know what your costs are. And that means having tools like work breakdown structures, where you list the tasks that are going to be completed, you develop your scope of work, you identify the hourly rate that's being proposed for all timekeepers, you estimate the number of hours in light of that scope of work, you come up with an estimate in terms of what the price might be if billing by the hour, and what the cost would be under a profitability model. So that's one input into the equation. But I think you also need to think about what's the value that the client is getting from this particular work. The conversation that Mitch and I had, ask the client, what is the budget we're working within here? What is your willingness to pay? What's the timelines? Like, that's project management 101. That you have to manage the triple constraints of time, cost, and scope. If it takes longer, it's going to cost more. If there's more scope, it's going to cost more. It's going to take more time. You can't optimize all three things simultaneously. So I think, Robert, I would tackle it that way. Understand the cost, understand the value that the client gets, understand the expectations in terms of the price, and try to develop a pricing structure that aligns the incentives to get the client what they want, which is still profitable for the law firm.
Yeah. And I think you look at it, the value equation, not the value that you're giving, but the value that the client perceives. right? Because those are going to be two different things. The client is looking at it and saying, this isn't that, it's important, but it's not earth-shattering to me. So I'm not willing to spend a zillion dollars on this. I'm willing to spend this. And really, and it's asking questions. Just ask a lot of questions. Okay, so what are we doing here? So what happens if it doesn't get done? How does that affect you? Well, don't you think there's some value to that? If it gets done faster, is there some value to that? And then, build it along those methods, those lines as well.
Mitch, I love that comment because I think too often what happens is an email comes in and like, how much is this going to cost? And then the expectation is a document comes back. It should be a dialogue. It should be a conversation, right? Couldn't agree more. Sorry, Ken.
Oh, no, that's fine. I was just going to say with, larger things like mergers and acquisitions and everything, some of that value that you're receiving is insurance, because you have a trusted relationship, and that's part of what you get out of the relationship with the firm, that you're going to get the deal done, or you're going to figure it out and know why you can't get it done, which is unusual. So I think there's that aspect of it. But I also wanted to just highlight that there is room there. The Lathams, the Kirkland Ellis's, the Scaddens, they get a premium that's pretty high because of their reputation. And there are a lot of fixed fee and boutique firms that can do just as well on an engagement and get a deal done for half price and still make a ton of money. So I think there's a lot of different ways to go about it. But at the end of the day, nobody's going to pat you on the back for saving a little bit of money when the deal doesn't go through. So that's really, I think, the tie back to the insurance angle too, and thinking about it from that perspective also.
All right. We also have a few registering questions. We've got John Wee, who had asked, with the fast pace at which AI forces industries to change their workflow, will the standard legal business model thrive? Paul, maybe you could start with this.
I think it will, but I don't think all firms will thrive in this environment, right? I'm a strong believer in this idea that we're entering into a new era in human history. I think this is equivalent to moving from the agricultural era into the industrial era. I think, but it's happening far quicker. And I think the most important skill that law firms can develop in this era is the ability to adapt to change. And the law firms that are staying in the old way of doing things, not looking at alternate pricing structures, not looking at their compensation systems, not thinking strategically, not understanding their costs, they are going to suffer in this new environment. And I think they are not going to thrive. But if there are law firms that are forward thinking, the future-proof law firm in the nature of this discussion, looking forward, thinking about the systems they need to develop, methodically and systematically building up the capabilities to thrive in that environment, and never stopping that process, like developing that capability to continuously improve themselves. Like no one's got a crystal ball and can predict exactly what the future brings. The law firms that will thrive in this environment are the ones that adapt to change that exists now, but continue to adapt to it as the world changes around us. So the answer is some of them will do better, I think, and some of them will fade away if they can't adapt to these changes.
Mitch or Ken, do you have anything to add?
Okay, so let me jump in. I think it's a very interesting time from a small solos and small perspective, and that you will see those firms do very well because that's kind of how they're wired, because they have to be more entrepreneurial, they have to be more business minded, because if they don't stick around. And I think that the hyper AI world that we're living in will only help them do higher level work and do more work, be force multipliers for them to be able to do more work and manage their costs a lot better. So I think that end of the market will really start to explode over the next few years. I'm worried about big law firms, because at some point you're only going to need a certain number of lawyers with AI and law clerks to do the same amount of work that you're doing with, 80 associates. And so I think that we'll see how that plays out. I just think that's an interesting dynamic, is if you start to think about what your associates do every day and whether or not you can do the same amount of work with less associates.
I'll just mention very briefly that AI native law firms are something to watch. Ones that are going through and defining agents that will actually do things. So you have AI actually performing some of those tasks. When they're able to, and this is the signal of it, when they start to take some work away from big firms and that gets noticed, that's going to drive the behavior changes that need to happen in big law. And big law, some big law will be able to turn the corner, and other big law firms might not. Maybe they have to go out and buy an AI native law firm to do that and work through that to be able to make the changes.
All right, we have another question from Robert. He said, I'd be interested to hear how firms are actually defining and measuring a profitability these days. Beyond the traditional metrics like revenue per lawyer or realization rates, what are you using to determine whether the firm and individual practices are truly profitable? And more importantly, once you have that definition, how are you aligning individual lawyers' incentives and behavior with the overall profitability of the firm? In other words, how do you make sure that what's good for the lawyer is also good for the firm, especially as AI starts changing the economics of how we deliver legal work? Paul touched on this when he mentioned shadow billing. How can you determine profitability if lawyers are just putting time in when they haven't even spent that much time, but they want to show time to build up to the court?
I've got some thoughts on this one. I'm happy to jump in there too. That last point's a really good one. Um, uh, uh, how do law firms define profitability? I think you look at 100 law firms, you're probably going to have 100 different ways to do it. It's very personal to the firm. We embarked on this journey probably 6 or 7 years ago and developed a profitability model. We canvassed all the ones that were available. There's lots of cost accounting principles that you can apply. You look at what's the overhead you're attributing to every timekeeper? What's the amount of compensation you're paying them? Divide that by their billable hours. That's their cost per hour. Compare that to the effective rate on an engagement to look at the margin. That's one way of doing it. We found what that was doing was actually leading to unintended consequences that ran counter to our strategy. So, for example, could be in that case, the busiest person could be your cheapest person. And or most profitable person, I should say. So give all the work to the most profitable busy person and take a work away from the people that need the work the most. So you're not optimizing for the utilization of all your timekeepers. So what we ended up doing is we developed a model that was more fluid and aligned with our strategy. We want to delegate work to lower cost timekeepers. We want to still remunerate and see the value in some of our areas where we have slightly reduced rates. We wanted to have our lawyers partners buy in to the profitability model. So we actually calibrated it in a way to optimize it for achieving higher realization, but delegating appropriately to lower cost timekeepers. And then we tie that into our compensation criteria. So at the end of the year, we're looking back at the billings of a partner and the revenue that they've generated as a billing or responsible lawyer. And we look at the profit margin that results from. It's not just the top line revenue amount, it's the profit that's been generated as a result. And that's not the only factor, but is one of the factors that we consider when we're assessing our partners and compensating them. That last question, I don't know how you deal with that because the way that you are calculating the cost is the amount of hours that have been written down on the file. And so if people are fudging their hours and not truly spending that time, they're getting compensated for that, so the firm is incurring the cost, but it is skewing the accuracy of the numbers. So what is the true profit? It's difficult to say. So people will game the system. I think what you need to do is have incentives in place so people don't have incentives to game the system. Compensate people less for their personal productivity, but more for the profitability of the overall matter that results. So if you're putting in incorrect hours, you're diminishing the profit. If you compensate them for the margin and the profit, hopefully the behaviors are aligned. So, but really good question.
Yeah, for sure. Ken, Mitch, would you have anything that you'd like to add?
No, I think Paul nailed it.
Yeah, I just say if
Okay.
you have 100 firms, you're going to have more than 100 different ways to do it.
Yeah, agreed.
All right. then we will wrap up tonight's discussion. I want to sincerely thank our panelists, Ken, Mitch, and Paul. Thank you all for sharing such thoughtful and practical perspectives tonight. I think one of the biggest takeaways from this conversation is that future-proofing a law firm is not just about getting more clients or billing more hours. It's about building better systems, creating operational clarity, improving delegation, strengthening pricing strategy, protecting team capacity, and growing in a way that remains sustainable long term. I also want to thank Ekwa Marketing once again for sponsoring today's panel and for providing the complimentary strategy session opportunity for attendees. And before everyone leaves, please take a moment to complete the feedback survey when you exit the webinar. Your feedback genuinely helps us improve future panels and discussions. And to everyone who joined us live tonight, thank you so much for spending your evening with us. We really do appreciate your time and participation. I'm Angie with Dominant Law. Thank you again and have a wonderful evening.
Thank you.
Thanks very much.
Thank you. See
Bye
you.
now. See ya.
Thank you so much.